Hello, I'm Andy Agafangelo. I'm very, very proud to be the founder of the Transparency Task Force. The Transparency Task Force is something I set up in 2015 without any particular plan in mind, than the general intent of trying to get the financial sector to behave in a more transparent, truthful, and trustworthy way. And my intentions came about because, having joined the financial industry in my early 20s, on several occasions, I've personally witnessed various kinds of misconduct, malpractice, misfeasance. And despite reporting what I knew to be wrong, the companies I was working for didn't protect me, and I ended up losing my job on 3 occasions. It was a particularly bitter time of my life, quite frankly. And over the years, I kind of started thinking more about the dynamics in the industry that were causing the malpractice that I was witnessing. And I started to get really interested in understanding why the financial sector behaves the way that it does. And let me just paraphrase how it behaves. The financial industry, measured by the amount of fines, is by far the worst offending industry of all in the UK. I'll put some information into the chat shortly to evidence the point that I'm making. The second worst offending industry, I think, is the aeronautics industry. And the financial sector is fined far more than twice as much as the second industry. This is a big problem because the financial industry has to be trustworthy to function successfully. If you think about it, if you take trust out of financial services, there really is nothing left. The word credit comes from the Latin word credere, which means to believe in. The financial sector ought to be something that we can all believe in, that we can have trust and confidence in. And for that to be the case, we have to have a regulatory framework that's effective. Our regulators have got to be at least pretty decent. I don't mind sharing with you that roughly an hour and a half ago, I found myself getting rather emotional talking to some TTF members on Zoom about an hour and a half ago, talking about how sad I was, and frankly, how sad we were, at the ongoing realization that there are parts of our system that simply do not seem to behave with a sense of honor and integrity. And when that's a commercial organization behaving without honor and integrity, it's totally inexcusable. But you can almost kind of understand it if it's an organization being led and run by greedy people who put their own profit margin or their pay packet, their bonuses, of anything else. And of course, there are loads of organizations like that. But when you have a regulator, that, to all intents and purposes, seems to be behaving as if they are morally bankrupt, it's enough to make you feel really sick. And when I think about what this conversation tonight is all about, that's where my thoughts go. You'll be aware this conversation tonight is about the all-party parliamentary group on fair business banking's attempts to make the Financial Conduct Authority do the right thing. In other words, to make the Financial Conduct Authority make the banks pay compensation to people that deserve to be paid compensation to. And this judicial review goes back to when John Swift KC published his report, which basically said lots of things have happened here, FCA, that should not have happened. You should get on and make the banks pay compensation. I'm paraphrasing to the nth degree here, but that's the gist of what he said. You would expect the FCA to respond to that with, okay, that makes sense. We've paid you X million pounds, John Swift KC, to do this report independently of us. We wanted to get to the bottom of what's gone on here. Your independent report has told us that there's a lot of things that need sorting out here. But first and foremost, we now need to organise a way for these folks to get compensated by the banks. But that's not what the FCA did. We all know what the FCA did. What they did was to say, no, I'm not going to do it. And you're not going to make me. I've got enough power, the FCA was effectively saying, to prevent you or anybody else making me, the FCA, make the banks do the right thing. And this takes me back to my childhood and maybe yours too. We all experience bullies in one kind of way or another at school. Bullies are horrible, but there's surely nothing worse than the kind of teachers who, for one warped reason or another, would turn a blind eye to a bullying kid. A teacher that wouldn't step in and make the kid stop doing what the kid was doing that shouldn't have been doing. That's totally inexcusable. And I would put it to you, ladies and gentlemen, that that's the kind of thing we've got going on here. We have a regulator that is, to my mind, knowingly doing the wrong thing. That word wrong is a pretty powerful word, especially as I understand it in a legal context. I understand that John Swift KC literally said the word wrong in his description of what the banks were doing. Wrong. It was wrong for it to happen. It shouldn't be happening. This is wrong. Powerful word, simple word. We all understand the word wrong. And the FCA's response was essentially that of an entity that must, to some degree or another, for reasons we may never ever understand, must be, at least in part, morally bankrupt. Morally bankrupt, deliberately, knowingly doing what they must know to be wrong. Later on, I'm going to talk about my own thoughts that went through my mind when I was there at the hearing at the Royal Courts of Justice, along with several of you. I'll reflect on those thoughts later. But what I'd like to do for the moment is talk about Bully Banks, an organisation that some of you folks here, and particularly Andy Candy, played a huge part in getting off the ground, a community of victims of banking misconduct called Bully Banks, that through various iterations evolved into what we would now recognise as the All-Party Parliamentary Group on Fair Business Banking. I'm deliberately making reference here to the words bullying because, to my mind, that's what this is all about. Bullying behaviour by the banks, in some way allowed to continue by a morally bankrupt regulator that seems okay with banks bullying people. One of the reasons I got rather upset earlier on this afternoon is because I was speaking about one of our members, Ian Davis, who sadly committed suicide as a consequence of losing all his life savings. He was a nice bloke. Everybody that knew Ian would know that he was a really nice bloke, and he lost a huge amount of money just as he was approaching retirement. A really nice, straightforward man, very, very easy to get on with, very popular. I got to know some of the people in his village. I flew up to Scotland to go to his funeral. And the reason I'm talking about Ian Davis is because I'm absolutely sure he didn't hang himself because he was scammed. He hanged himself because he then spent 2 or 3 years after being scammed, tirelessly trying to get the regulators to do the right thing and get involved and help him and listen to what he was saying about literally the criminals that were involved in the London Capital and Finance scandal. I'm very, very deliberately contextualizing today's conversation in a manner to remind us all that we aren't simply talking about legal process here. We aren't really talking about regulatory stuff. We're not talking about courts and laws and rules and regulations. We are talking about human beings. In the summer of last year, we published our guide, Faces of Financial Crime. I'm really proud of this piece of work, especially as it was all done by volunteers, etc. The case studies of 22 people who are victims of financial crime of one kind or another, many of them victims of banking misconduct, exactly the sort of thing we're going to be talking about tonight. And I feel duty bound to remind everybody that so many people's lives have been completely and utterly shattered by the kind of malpractice and malfeasance, misconduct and mis-selling that has gone on, that the FCA for some reason seems to kind of be comfortable with. If they weren't comfortable with it, surely they would have made the banks do something about it and pay redress to people who ought to be paid redress to. So please do remember the importance of the topics we're talking about. I'm going to share my screen in a moment, and I'm going to show a short TV clip. It's Kevin Hollinrake MP, who used to be the chair of the APPG on fair business banking, chair or co-chair, talking on Sky TV about why an attempt at that time was being made to get this judicial review off the ground, and why there was going to be an endeavour to raise money, to ask people to find a way to resource the legal machinery necessary to try to get justice to happen. The harsh reality is sometimes in life you've got to stick your hand in your pocket and just pay something towards something to make things happen. So I'm going to play this clip. It's about three and a half minutes. I personally think it does a really nice job of kind of bringing the whole narrative around this issue to the front of mind. And I hope you enjoy watching it. I should be able to play it for you all now. You may need to turn your volume up, Max. You won't hear it very loud, but you should be able to hear it reasonably comfortably. So here's Kevin Hollinrake when he was the official running the APPG. Here we go.
Our group of MPs has stepped up a legal fight over the city regulator's decision not to widen a compensation scheme for businesses missold billions of pounds worth of loans by some of Britain's biggest banks. The all-party parliamentary group on fair business banking has sent a letter before action to the Financial Conduct Authority seeking a judicial review of its handling of the redress programme. Well, Kevin Hollinrake is the co-chair of the all-party parliamentary group on fair business banking, and he joins me now, or rather he was about to. Is he there? He is there. Kevin, good to see you this morning. My heart skipped a beat there. Look, for people not familiar with this saga, when did this alleged mis-selling take place?
Really late 2000s, just before the financial crisis and afterwards. So, this was another banking scandal. These banks knew that interest rates were going to fall, yet they sold these products that kept in their interest rates high. And also it meant a big breakage cost. So it prevented lots of businesses from rebroking their finances and moving elsewhere. So it killed lots and lots of businesses. And that's why the review scheme was put in place. But arbitrarily, the FCA decided, after lobbying by the banks and indeed the Treasury, to make a limit on what size of business could enter the scheme. So lots of people were left without justice and compensation.
And as far as you're concerned, this was down to political leaning on the regulator then not to pay out?
Well, it's not me saying that. That's in the review. So the FCA commissioned a review of the scheme. Jonathan Swift did that review and established that there was lobbying by the banks and indeed the Treasury itself to limit the scope of the scheme. And that was purely to save the banks money. And they knew it would exclude lots and lots of businesses, about 5,000 businesses, 10,000 sales of swaps. We think at least £2 or £3 billion of compensation that's not been awarded to lots of SMEs. And these people's lives were devastated. Many people lost their businesses, lost their homes. Some people inevitably lost their lives through that process, because if you're in business, your business is everything to you. So devastating consequences and treated as collateral damage, in my view, just absolutely inappropriately.
And do you think you are going to succeed in getting this judicial review?
Oh, we hope so. We've got a fundraising campaign. We need to raise the money to do it. Housefeld, the legal firm, are helping us with this, and but we do need to try and secure the funds to be able to do this. But very much hope so. We can take the action forward, and also that we'll get a positive judgment in the case. I mean, the FCA, it cost £7 million to commission this review. It took 2 years to do it. The central recommendation by the very renowned QC, John Swift, who conducted the review, was to widen the scope of the scheme. And the same day they received the report, the FCA simply dismissed that recommendation, totally inappropriately, in my view. I mean, his words were their decision to limit the scheme was not consistent with the standards of a skilled regulator. I find it hard to see how they can not widen the scope of the scheme on that basis. So let's hope the judge agrees with us.
All right, Kevin. Hopefully see you again in future to talk about this. Thanks for joining me today.
Thank you.
Okay, so that's
Our group of MPs.
So a legal fight over the city regulator's decision not to widen the compensation.
So that's a really nice summary of where we were prior to the fundraising getting going full steam ahead. And I want to take everybody back to that fundraising stage of the process, because it was a particularly important part of the process. And I want to remind everybody what this community and other communities managed to do, chipping in to try to get the end result. There it is. A total of £101,130 was raised through a crowdfunding effort to get the APPG's judicial review off the ground. And I'll put a link to this page in the chat, because it takes us through to the recent judgment, so on and so forth. So I think we probably ought to spend a moment just reflecting on what we've collectively managed to achieve, and frankly, what Kevin Holland-Rake managed to achieve in leading the APPG in the direction of the judicial review. The decision was made to fight back. That was probably the hardest decision. There you are in the playground, great big bully in front of you, picking on you. Do you fight or do you run? And they decided to fight. Bloody well done, as far as I'm concerned. Excuse my language, folks, but bloody well done. That took some courage and that took some guts. And the next decision was to actually generate the funds necessary to actually attempt to get a judicial review. This is like just getting on the pitch, winning the chance to play the game. And we collectively did that. Many of you put hands in pocket to come up with the money necessary to drive this judicial review forward. And Simon and his colleagues have done a great job. The evidence is we're now talking about a judicial review that is actually happening. The game is on. The referee has blown the whistle. It's happening right now. And who knows where this story is going to end. It could turn out to be a battle we lose. It could turn out to be a battle we win. But I'm absolutely sure, to the very, very inner self, that when confronted with a bully, the best thing to do is always to fight back. Because even if you can't save yourself, you're going to make that bully think twice next time he or she's thinking about bullying somebody else. And if people before us had done a better job standing up for the banks, then maybe the banks would not be behaving in the kind of egregious way that they have been. We're going to be going to Simon Bishop now. Simon Bishop and his colleague Ned Beale at Housefeld have become very, very participatory professionals in our environment, and we're very, very, very glad to have their support in all kinds of ways. Housefeld supports the Transparency Task Force, which is a massive thing. It really is a massive thing, emotionally as well as anything else. Just having some support like that is really, really important. And they've been working hard, and they've been working diligently, and they and their colleagues have been working very, very skillfully to try to bring about the justice that's necessary. So before we do anything else, folks, let's please put our hands together to applaud several things. Well done, APPG and Kevin Holland-Rake, for deciding to fight. That was a courageous decision. Well done to them. Well done to all of us for giving it a go and raising some money and being there in the courts of justice and doing all the stuff we've been trying to do collectively as a team to try to get this JR to be as successful as possible. Well done to Simon and Ned and all the people at Housefeld using their talent, their experience and their judgment to do a damn good job standing up against this bully. So can we please put our hands together and show our appreciation to everybody that's been involved, including ourselves, in getting where we've got to so far. And on that note, I'll pass over to Mr. Simon Bishop. Simon, thank you very much. Thank you.
Thanks very much for that introduction, Andy, and also for the summary of how we got to where we are, which has, I think, been very useful and teased me up nicely to sort of say an update on what's happened in the past 3 or 4 weeks and what might be happening over the next few months and the trajectory of the judicial review that we're pursuing on behalf of the APPG. As Andy said, as the clip said, the clip referred to the issuance of a pre-action letter, and that was the first step in the judicial review, and we sent that in February 2022. And you then are on a timetable where you have to get your case played, you have to describe your points of claim, you serve it, you receive the points of defence from the FCA and so on. We closed all of that off at the beginning of May 2022. And then there was a period of extended silence. We were in touch with the court on a kind of monthly basis to try and get a sense from them as to when we could expect a decision. And I should say just there, what normally happens in a judicial review is that you get a decision from the judge as to permission on the basis of the papers that are filed rather than having a hearing. Anyway, months went by and actually then a year had gone by and we felt that something was not right. We ended up having to write a letter to the president of the King's Bench Division at court. And it turns out that the filings had effectively through human error not made their way to a judge during all that period, notwithstanding our chasing of the court staff on a regular basis. So we've unfortunately been the victims of a kind of administrative mess up at the court, which is very unfortunate because it's meant that we're now a year on from where we might have hoped to be. However, the positives that came from that are that the court convened a hearing and convened it quickly. We broke the kind of backlog of correspondence problems, and then 4 weeks later we had a hearing listed. And that was the hearing that Andy was referring to, which took place 3 weeks ago. There was a full day hearing at the Royal Courts of Justice in front of Mr. Justice Fordham, who is a very well-renowned public and administrative law expert. He was a barrister and a silk for 15 years before becoming a judge, and knows public law inside out. And the hearing was, to be very short about it, a complete success. We effectively got everything that we were seeking in relation to our application. We have been given permission to pursue the judicial review on behalf of the APPG on each ground that we sought to do so. And more than that, the judge handed down a very helpful judgment. He really got into the issues, really got into this question as to whether or not the FCA has acted unlawfully, and was not at all persuaded by the arguments made by the FCA and the FCA's legal team. It was an enormous success, effectively. And we were very pleased to come out of that. We've got a lot of excellent fodder in the judgment itself that's going to help us in terms of the routes through investigation and disclosure and evidence in order to develop the case as we go through the timetable, which I'll come on to. And we now have some directions. So the court has effectively told us what the timetable is for this case now to a full hearing of the arguments. We expect that hearing to take place in early 24, probably January, February, we hope. In the intervening period, there is a great deal of work to do. We will receive the FCA's detailed defence at the end of September. We will then have to, I suspect, make an application in relation to disclosure. So up to date, the FCA has not, we would say, complied with its obligations in relation to disclosure in this case. When you bring legal proceedings against a public authority, they have what is called a duty of candour. So they have a legal obligation to proceed with the litigation with all of their cards face up on the table. And we found in the course of the pre-action correspondence and also the pleading stage that they were not doing that. And we had to fight and interrogate and forensically examine the way in which they were dealing with this in order to reveal documents, categories of documents and so on that were disclosable in the case. So we've had to do that already, and we expect that we are going to have to continue doing that in order to get to the bottom of all of the evidence that's relevant to whether or not this decision that we're complaining about was lawful or not. So there's a lot of work to do in that sense. In parallel, we will also be looking to assess what witness evidence is going to be relevant to this case. The FCA has an obligation to tell us which witnesses it's going to call, and we will hear about that at the end of September at the same time as getting their detailed defence. But we have 2 or 3 individuals in mind who we think will have very relevant evidence to the case, and we will need to see whether or not the FCA offers them up as witnesses. So that's a sort of snapshot of where we have got to. It's now 3 weeks old, and I suspect many on here have it, but it's well worth a read, the judgment, because it will give you a sense of just how short the shrift was given to the FCA in relation to the arguments that they were advancing. And it's a very helpful platform from which to advance on this case. Overall objective here is to persuade the court that the decision taken by the FCA to do nothing in respect of or in response to the SWIFT review was unlawful. So the FCA has, the court has the power to declare that that decision was unlawful and to quash it, so effectively nullify it of any effect. And if we're successful in that, we will be successful in the judicial review, and the FCA will have to go off and make a lawful decision. And obviously we will, in the course of what we're doing, hopefully pull out what considerations the FCA is going to have to give in order to make that decision lawfully. So that's really the process that we're going through, and the key objective. Obviously, we say that a lawful decision will include a recognition that they acted unlawfully in 2012, 2013, that over 10,000 of the relevant transactions were unlawfully excluded from the compensation scheme, and that a new scheme ought to be set up to compensate those excluded customers. So that's the objective, but there's a long way to go in order to get there. And I keep emphasizing that because obviously what's key to this enterprise is to ensure that we have the funds to continue to continue to undertake the case. There was an incredible response from this group and from others in our first round of fundraising. And in a very short time, we got to our critical mass of funds of £100,000 in order to proceed. And the response was, quite frankly, remarkable in everybody contributing. And I think Andy has alluded to that earlier, the contributions of everyone. In the course of bringing this case to even the permission stage, we have been required to do significant amounts of work that you wouldn't normally expect to do, simply because, as I say, the FCA has not and is not, and I suspect will not, comply with its duty of candour. So we will have to fight it every turn in order to ensure that the case is properly heard and that the court has all of the relevant evidence. So an important point now is that we have relaunched the fundraising campaign. We need to do our best to try and put those funds back up. It is in order to pay a very small portion of the APPG's own legal fees. So that's in relation to Housefeld, but also council and the various disbursements that are required in a case like this. But an important point to flow from the hearing that happened 3 weeks ago is that in addition to own costs, the judge has made a costs capping order. So this is effectively a very useful tool which reduces or puts a cap on the potential adverse cost exposure of the all-party parliamentary group. Were we not successful in getting such an order, the case would not have been capable of going forward, because there is a risk that if we go forward and lose, that the members of the APPG would have to pay the costs of the FCA, and those would be very high. And obviously that's just not something that the APPG or we could countenance. However, we have been successful now in obtaining a costs capping order to neutralise that risk. It's a novel costs capping order, and it's basically set as follows. The APPG will have an adverse cost exposure of 40% of any funds that it raises in respect of these proceedings, and that includes funds raised to date. So overall, that is an extremely positive development. It has facilitated the continuance of the proceedings because the APPG can proceed in the knowledge that they're not going to have a massive costs bill if they lose. But it also means that we now have to look to fundraise again to ensure that we can do all the work necessary in order to get the outcome that is so desperately needed in these circumstances. So this is a plea on behalf of the APPG, but on behalf of everybody affected by this issue, to spread the message as far and as wide as possible, to look at the sort of republished crowd justice page and see whatever further funds can be raised in order to pursue this case. I will just reiterate as a kind of closing comment, and I'm very happy to take any questions that anybody has, that Mr. Justice Fordham, my read, our read, and I think a common sense read of his judgment is that we're on the right side of the legal case on this, and that is encouraging in relation to where we might get to. We still have absolute faith in the claim, and we will be proceeding with it. But obviously we need to ensure that the resources are there to do so. So I should just say as a closing point, a huge thank you to Andy and to the TTF generally. They always do absolutely impeccable work in keeping this community together and keeping the narrative coherent. It's a huge support to a very serious legal case that we're doing here. So a big thanks to you, Andy, but also to all of you.
Thank you very much indeed. Thank you so much, Simon, for your kind comments. I think everybody involved with the TTF community and the people here tonight are people who have a sense of purpose about what we're trying to do, as well as there being actual banking misconduct victims here tonight. We've got others who are, campaigners who just are getting annoyed, frustrated, upset, angry because of the bad behaviour they're seeing in all kinds of ways. And if anything, this community is getting stronger and stronger and better because of this growing sense of purpose that we have, Simon. And there's a real sense of momentum, a real strong sort of current flowing through the work that we've got, fighting on all kinds of fronts. Thank you very much indeed, Simon. I'm going to ask you a couple of questions, Simon, if I may, just to kind of get the Q&A going. And then we'll be opening up to everybody. So folks, between now and roughly 7:30, we've got a chance to have a grown-up conversation about these issues, and everybody feel safe here. This is a safe environment to share your thoughts. There's no such thing as a silly question, etc. You know how we work.
I should just say, Andy, sorry to interrupt you, but I will unfortunately have to drop off at 7, but I've got until then. Okay. But very happy to discuss up until then.
Okay, thank you. I remember there was a note earlier. Sorry, I forgot about that. Okay, so my first question is, one of the questions that Justice Fordham wanted clarification on at the hearing was what types of people is this case all about? Could you just speak to that point, because I want everybody to understand the type of people that have been affected by this type of alleged banking misconduct and who could potentially benefit from a successful JR outcome. Thanks, Simon.
Yes, I mean, the short answer to that, Andy, is it's very difficult to say based on what we understand, in terms of statistics, in terms of understanding individuals, the types of business, the size of business. The excluded customers were those who were deemed quote unquote sophisticated. They were excluded primarily really on three bases. Firstly, if they had a group aggregate notional of interest rate hedging products of 10 million or more, they were considered sophisticated. Secondly, if they met the small companies definition, which is in all over various bits of legislation, including the Companies Act, then they were deemed to be sophisticated. And then thirdly, there was a subjective test that may be applied by the bank if they think that, notwithstanding not meeting those two tests, the counterparty was deemed sophisticated enough to understand the risks involved in the transactions. That resulted in 10,000 of 32 odd thousand transactions being excluded, and it's the 10,000 biggest transactions by definition. This case really is about them, and those people and those businesses and the effects that all this had on them. That's really what this case is about. And Mr. Justice Fordham quite rightly said, who are they? And part of the issue is that the FCA should know the answer to that question, because if you're going to make a decision to exclude from your regulatory protection a class of people, you ought to know who they are, and you ought to know the basis upon which you're making that exclusion. That's obviously one of the pillars of our case, but it also means that from a statistical basis, we don't really have a great deal of oversight or understanding of that group of 10,000 transactions, such that we can describe the types of business. We have anecdotal reports, and we know through the APPG of examples of clients and claimants who sit in that particular group. But it's a very difficult group to describe in any kind of coherent and aggregated sense, because that exercise has never been undertaken. Who are they? What sorts of businesses, what sort of sectors do they operate in, and so on. As part of all of this, it would be useful for us to, through the TTF, through the APPG, or through any direct or other means, to understand who that group is. So if there are means by which those who fit in the excluded group are able to come forward in it and explain who they are and the types of business that they operated in, the hedging products that they transacted, and so on, that will be helpful for us, because we will need, I imagine, in the fullness of time, to be able to explain that properly.
Thank you very much, Simon. And my final question before we go to everybody else, and if you were there at the Royal Courts of Justice a few weeks ago, please do kind of raise your hand and reflect on anything you want to say about your experience of having been there, or any thoughts that were front of mind. I'm thinking here perhaps of Jackie Roberts and Andy Candy and anyone else who was actually there. It probably makes sense going to you first of all. But before we get to that point, my final question for now, please, Simon, is this. I had to leave roughly halfway through the hearing. During the afternoon when I wasn't there, I understand that there was some attempt by the FCA's barrister to basically say something like, we the FCA couldn't agree to do what these folks want us to do because we'd already done a deal with the banks that we wouldn't do it. So something like that. Could you just explain what I just waffled my way through in a slightly more coherent way? What was that all about?
So the scheme in 2012-2013 was a voluntary scheme. That's, I'm sort of putting that in inverted commas. The FCA had at that time various regulatory powers to enforce on the banks in the face of widespread mis-selling, and presumably in leverage against those powers, negotiated with the banks to enter into contractual arrangements to set up the scheme. So the legal source and framework of the scheme was set down in a form of in a series of bilateral, and in some cases multilateral contracts. And in that sense, so what you have there is the FCA and the bank entering into a contract, exchanging various values, saying in exchange for you for our regulatory protection and our regulatory obligations and so on, you will go off and perform this function, i.e. you will look at all of your interest rate swaps that were sold during a relevant period, and you will assess the extent to which that they were missold and the extent to which redress ought to be paid. And it was a heavily prescribed contract. So annexed to that contract was a multi-page document setting out just how that redress scheme was required to be set up. Now, the bank makes two arguments in respect of this. Sorry, the FCA makes two arguments in respect of this now. Firstly, that a clause in that contract or several clauses in that contract are to be read such that those contracts constituted full and final settlement of all the matters that they describe. And so what that would mean, if that argument were to succeed, is when the two parties entered into those contracts, neither could do anything more about them again at a future point in time. And so effectively the argument there that the FCA runs is that it would be a breach of that contract in order for the FCA to look to set up a new redress scheme now. Secondly, they run an argument sort of more under the public law head, which is an argument of legitimate expectation. They say that the banks now have a legitimate expectation of this regulator, that this regulator is not going to do anything more about interest rate swap mis-selling because of the way in which it dealt with it previously. Now, I think on the face of it, those arguments will probably make people's blood boil because you know, it's you know, as a lawyer, I understand why the arguments are made and how they're made and why they're brought. And if I were acting for the FCA, I would also bring them. But from a common sense perspective, it sort of seems absurd that this might even be a possible thing. Now, what was interesting at the hearing is the judge really grasped all of that and did two things. Firstly, he made no ruling on this, so we don't have anything in the judgment that disposes of this issue. This is a live issue, and the judge who hears the full hearing of this will have to make a ruling if the FCA continues to advance these arguments. But the judge very helpfully probed, firstly, that contractual argument, and we went through the clauses in the contract. The barrister on behalf of the FCA made submissions as to why, in his view, in his submission, the effect of those clauses was for the FCA to surrender any future power in respect of interest rate swap mis-selling. Now, it's not a good contractual interpretation argument, and the judge really pulled that out in the course of the hearing. And in particular, there's a clause, I think it's clause 6 of that contract, which says this agreement will not have any effect in terms of fettering the FCA's future ability to implement its regulatory obligations. That argument, as I say, remains live. So the FCA will continue to run that argument. The judge did not make any finding on that argument. He simply extracted the positions and left them there. And so that is all he could do, because that's all you can ever have at a permission hearing. And he effectively did the same thing in respect of the legitimate expectation argument. Now, what that's all done is it's sort of put it on a plate. It's all there to see. The FCA seems to be continuing to pursue it. And that judge, reading between the lines, thought it was not a good argument. We obviously take the same view, and we made submissions as to that during the hearing. But that's where it is. Very important to bear in mind, though, the nature of the permission hearing. All that the judge has done is given us permission. So we don't have findings in respect of any of these issues, and that's why we have a full hearing coming up. But as I say, the way in which the judge extracted and unpicked these issues is very helpful for us.
Simon, thank you so much. Thank you very much indeed. Okay, who'd like to come in here with any comments or questions? Please do raise your hand, either literally, I'll try and see you, or digitally if you can. It's better digitally. Mr. Nigel Keds. Nigel, why don't you first of all tell everybody a little bit about yourself, just nice and concisely, just so everybody understands your perspective of somebody who is an alleged, I'm going to use that word quite a bit tonight, an alleged victim of banking misconduct. Nigel.
Yes, I'm a victim of banking misconduct, but not at all in connection with their interest rate hedging products. It's with a major high street bank, and it's been going on about 14 years. But all of the same issues of morality and honesty seem to be pretty much identical in all our cases. So I think there is a lot in common. But what I'd like to ask Simon to do now is just to tell us a little bit about the chosen counsel that'll be advising on this matter, because I think that would be of interest to everybody.
Thanks, Nigel. Do you mean our council or do you mean the FCA's council?
Yours.
Yeah, so we are instructing Thomas Rowe, Casey, and Anna Lindner. Thomas Rowe is a silk at Three Hare Court Chambers.
Yeah.
He's a seasoned public law and commercial law barrister. He's done lots of commercial litigation and also done lots of judicial reviews. He's acted for claimants in judicial reviews and government departments, though never the FCA. And he also has a lot of nous in relation to banking matters. We are also instructing Anna. I've worked with Anna on a number of cases in relation to interest rate swap mis-selling. Anna's a banking and financial services litigator specialist, and she knows the regulatory framework around interest rate swaps, COBS, MiFID, inside out. And she's also excellent in terms of putting pen to paper and making arguments. So that's our council team. Obviously, they are also a council team who have said that they will do this at significantly reduced rates. And so not only do we have top class counsel, they're also doing it at the most 25% of their normal rates, but probably much less than that. It's worth just, I will just...
Sorry, out of interest, it will also be interesting to know what you think about the choice of Denton's counsel.
Yeah, well, we made, and some of you will know about this, but the first letter that we got from Denton's was on this was a bit of kind of sleuthing on our part, but whenever solicitors send out letters, we have a matter reference number that will go in the top right hand corner of the letter. And it was clear that this matter reference number was under the supervision of the partner who acted for RBS in the Property Alliance Group case, and RBS in the Stuart Wall Opal Properties case. So there was in the first instance a fair amount of overlap between the bank advisors and the FCA advisors. That remains the case actually. The FCA's Silk, Richard Coleman, also often acts for the banks. So we made a big point about that over a year ago now, and they swiftly sort of recomposed their team so that that particular partner was no longer on the case. And they do a lot of work with the FCA, Denton's. So on its face, it's kind of salacious, but actually, you know, they are a big firm in the financial regulatory space. You know, we've made all the points that we can about potential and perceived conflicts, and obviously regulatory capture is a big point of what we're saying here. But yeah, you know, they were, you know, I suppose that it's not inappropriate for me to say this, but they were fairly tail between legs after the permission hearing.
Thank you.
Nigel, thank you. Thank you, Simon. Who'd like to go next with any comments or questions? Please raise your hand, literally, digitally, however you'd like to. We can see Richard Loxton. Richard, please take yourself off mute and as succinctly as you can, share with us your thought. Thank you.
Yes, thank you. Can you hear me?
Yes.
Okay, a very simple question is that which firm, or sorry, which chambers is the FCA using? Because I've been pursuing my own case against the FOS, and I've almost by accident got to roughly the similar position that you've got with the FCA. So I'm interested to know which chambers the barrister that the FCA is using.
So the FCA has two barristers, as do we. That's just not, and they're from different chambers, which is not. This is very common. Mm-hmm. The Silk, Richard Coleman, is from Fountain Court, and Fountain Court are very well respected, high quality chambers who almost always act for banks. And the junior is from Blackstone, and Blackstone Chambers is another. They have a kind of a mixed practice, much more mixed practice at Blackstone, but they do a lot of banking and regulatory work as well.
Yeah. Okay, no, because the barrister that acted against me when I was dealing with the FOS came from 39 Essex Chambers. Does that has any significance to you?
No, I mean, so Anna Lindner, our junior, is from 39 Essex. I think that sort of analysing sets of barristers can only take you so far, really. They are all self-employed lawyers. They join chambers partly because of a kind of sharing of costs and expertise in certain practice areas, but often, I mean, I'm litigating a case at the moment where we are instructing the same barristers in the same chambers as the defendant, and the deputy judge is also a barrister in that chambers. So I wouldn't attach too much weight to the chambers, other than that 39 Essex are a good set. I mean, that, you know, they're sort of quality set barristers.
Yeah, no, that's fine. Thank you much.
Richard, thank you. Simon, thank you. Who'd like to go next with a comment or a question? You're unusually quiet tonight, folks. Gertch Samra, Gertch, go for it. Please take yourself off mute first of all. Thank you, Gertch.
Hi, good evening, everyone. I was in the interest rate hedging review that was carried out by Clydesdale Bank back in 2013. It took them to the end of 2014 to come back with an offer, and that basically was, you know, yeah, we've done wrong, we've overcharged you this amount, and we'll give you that back plus statutory interest. And if I wanted to claim for any consequential losses or anything else other than just that straightforward redress, then it meant submitting a load of stuff, and they'd recommended getting independent legal advice, and it looked like it was going to get complicated. I did a Google search trying to find lawyers with experience of dealing with these things with the banks, and everyone I found said that they couldn't help because they normally work for the bank. So having rung about 5 to 6, I gave up then, and then I signed the settlement and got the basic redress. Now, you mentioned a clause in there where, you know, you're signing to say that this is full and final settlement, blah blah blah, and that you know, there's, you know, to deal with this matter, and that you're not going to take that. Well, you're basically giving up your rights to any further action on that, and you said that the FCA lawyers were putting that clause through in their contract to say that, well, their hands are tied now, they can't do anything else. But is that a fair clause to put in a contract or settlement agreement or whatever, if you've knowingly been less than honest with the truth and what you've done? So if you've deliberately you know, limited your liabilities, etc., one way or another, and that's basically what the FCA have done here, haven't they? In the redress scheme, they've eliminated loads of people, done a deal with the banks to say, well, that's full and final settlement, but it's not honest, is it? So can they rely on that clause and that contract?
Interesting question, Gertch. Simon, we're talking about fairness here. What are your thoughts about the fairness of what the FCA did?
Well, I mean, I think there's a few things in there. I think insofar as the settlement agreement between the FCA and the banks is concerned, we wouldn't even we don't have a basis upon which to say there's dishonesty. That you know, and I know that there's a strong sense that there was. We don't have a basis, nor do we need to. The contract is drafted in such a way that we're pretty sure that it would be interpreted such that it hasn't tied its hands and it can take future action if that action is what it is obliged to do in terms of its mandate. We wouldn't need to go near any sort of arguments of dishonesty in order to achieve that. There is also another public law argument that we haven't yet looked at, but will need to look at, as to whether or not the FCA even has the power to contract out of its regulatory obligations. It's the concept of that is ultra vires, which means without power, and instinctively, establishing an ultra vires argument can be knotty and technical. But instinctively, it seems to me that there's a fair argument to say that any attempt to do that would be ultra vires, and the effect of that would be that in terms of the settlement between the FCA and the banks, it would be unenforceable. It's not an enforceable provision because the FCA never had the power to agree to it. We're obviously going to look at all of this much closer as we get through these proceedings, but it will be a contractual interpretation, legitimate expectation, and ultra vires arguments to look at. Gertch, all of that's slightly different to your situation, where there's often in litigation there will be settlement agreements, and settlement agreements will often require parties to surrender any future right in respect of the matters that are being alleged to be settled. You would need to get sometimes you can unpick those settlement agreements if there's evidence of dishonesty or that they were procured by way of deceit. But you'd need to get advice on that to see whether or not that applies in your situation.
Yeah, thank you.
Thank you, Gertch. Thank you again, Simon. The topic we just covered is of massive interest to Stephen Barker, I think, who is actually the next person speaking. So, Stephen, this will be the final question for Simon, folks, because he'll be dashing off shortly. The conversation will continue into other areas. Stephen, to you as succinctly as you can. Thank you very much.
Thank you, Simon. The most important thing is for this to continue, and therefore I'm going to focus on that. I'll leave the law with you and your colleagues. And the issue really now is either raising the money to go forward, or what's the possibility of after the event insurance kicking in to not pay for the case going forward, but you did mention in your introductory remarks that we would have to raise possibly the 40% capped cost order. And I got the impression you were thinking that had to be raised sort of now as part of this fundraising.
No, so and it's helpful to raise that, Stephen, because I'll just clarify it, and it's quite complicated.
Okay.
It's almost like we've got a kind of structured collar sitting over our costs regime.
Oh, you need to get advice before you start messing about with structured collars.
Well, exactly. So the plain point here is that we have a costs capping order in place. Number one.
Yeah.
That limits the APPG's adverse cost exposure.
Yeah.
The terms of that cost capping order are that the APPG will never be exposed to more than 40% of all of the funds that it raises. So what that means is of the 100k already raised, 40k of that now has to be ring fenced. Yep. For the purposes of adverse costs, and 40p out of every future pound that is raised will have to be ring fenced for the purposes of adverse costs. So what it means is that our original costs that were raised have now been depleted by 40k, and it will mean that future fundraise will also have to accommodate 40% in respect of potential adverse cost risk.
So can you insure that out?
The insurance market,
the cash flow.
Insurance markets can insure anything.
Yes,
to an extent. They won't insure this, I don't think, because we are not seeking financial reward, and there just simply isn't enough in it in terms of the premium versus the exposure to make it worthwhile. We have contacts in all corners of the litigation funding and insurance market. And I do not think that this is an insurable risk.
Worth asking.
Definitely, but I mean, we have. I mean, we did at the outset. Oh. We did a full canvass of the insurance market at the outset, and it's very difficult to insure cases where you're not seeking compensation.
Simon, thank you. Stephen, thank you very much indeed. Okay. Simon's going to be dashing off now, folks. We'll carry on talking about some other areas. In particular, I wanted to explore the extent to which we should be trying to get the court of public opinion on our side, because if the case is won in the judicial review, we're going to want to maintain the momentum built up and to get as much support in the courts, out of the courts, for the FCA then doing the right thing, having effectively been told off for not having done the right thing in the first place, assuming the JR is won. It's a big assumption, of course. Can we please put our hands together to thank Simon for his time tonight and sharing this update with us? Simon, thank you very, very much indeed. Thank you. Thank you. Cheers. Have a good one.
Thank you all. Good to see you all. Bye-bye.
Thank you. Bye-bye. Bye-bye. Okay. So one or two of you were there on the day at the Royal Courts of Justice. Hubert's got his hand up. We'll go to Hubert. I'll be keen to hear from Jackie from the APPG if Jackie would like to speak, and also Andy Candy if he would like to speak. But we've got 20 minutes or so, folks, to share what other thoughts we have. As I've mentioned, there are a few things I'd like to cover, including the general point about building support in the court of public opinion. Hubert Armstrong, please take yourself off mute and share your thought, Hubert, as succinctly as you can, please, sir. Thank you.
Okay, thanks again, Andy. First of all, I'm delighted to see Gersh Samara there. Gersh helped me reject my case in Belfast, and he was good enough to wear a yellow vest and hand out leaflets at golf clubs and the rugby club and all the rest of it. And I thank Gersh very much for that. We flew him over to Northern Ireland. I don't think he'd been here before, but the reason that I highlight Gersh and David, forgot his second name, but he came too from Birmingham.
David Farndon.
Publicity, David Farndon, exactly. Publicity is the one thing that the banks do not like. Adverse publicity, they react to very quickly. As I stated last night, I think, when my wife and I wore yellow vests and handed out leaflets in front of Danske Bank in Belfast, the bank reacted almost immediately. I was there from 7 o'clock in the morning, and at 2 o'clock in the afternoon, I got a tap on the shoulder. It was the PA to the CEO of Danske Bank, Kevin Kingston, who is no longer there, by the way. I was brought in, and really, he was in a panic over the amount of publicity that we had garnered over a period of a couple of weeks. We protested outside every branch of Danske Bank that we could, including every sponsored event that they sponsored, and they have spent a fortune on sponsorship in Northern Ireland. It has brought them to the position of top bank in Northern Ireland. They do not like bad publicity. I believe they're a bunch of sharks. I believe that, as has been stated by numerous speakers over the last 2 nights, that they know every trick in the book. They will pull every trick in the book. They will leave documents out. They will prevent documents going in, and they just continue to do so. It's my considered opinion that unless we get out with flags, now this all sounds a bit bizarre. I'm 80 years of age. 7 o'clock in the morning is very early for me. And to stand in the rain and to wave a banner or hold a strap is not very comfortable. And I'm quite sure, looking at the age of most of the folk on camera, they're a lot younger than me. But it certainly was the most productive that I've managed to get out of the bank. I've also written to Copenhagen, and I've also had very good cover by the Sunday Mail and by the Belfast Telegraph and by Reuters. That has all taken a keen interest. I would propose, from my own point of view, that I will be chasing the Belfast Telegraph and the Mail again and Reuters again. And I shall be speaking to Rachel Wilcott probably tomorrow, if I can get a hold of her, to publicize this event that Andy has put together. I think it is time that, I mean, in Northern Ireland, we don't talk to each other about our problems. We don't admit that we've got problems. We don't like to do that. That's embarrassing. And we don't like to be humbled like that. But it is the only way, I believe, that we can get the people of the UK and the SMEs and their employees who are being done out of their salaries, wages, whatever, They're the only people that are going to bring this to a full conclusion. Pressure from the people, and the people will speak. The banks will have to listen. Thank you, Andy.
Hubert, very, very well said, sir. I'm absolutely aligned with what you just set out. I'm going to talk about the rally for better financial regulation that we ran last year. It was inspired by work that had previously been done by Andy Candy and the Bully Banks folks years before. And Andy Candy helped with some of the thinking around it. I'm just going to share my screen to bring this thing to life. We created a brand new website for it. You can see it here, the Rally for Better Financial Regulation. It was in May last year, if I remember rightly. The route of the rally, just in case you wanted to know, is what I'm about to show you when this page opens up. The route of the rally was, as it happens, quite bizarrely, we started at the Royal Courts of Justice. At the top right of this map, the Royal Courts of Justice. We walked down here along the Strand. I remember it started pouring down at about this stage. We walked along here to HM Treasury. And at each one of these stops, we had people with a microphone standing on a box giving short speeches, including some politicians, which was pretty cool. From HM Treasury, we went to Downing Street, and from Downing Street, we went to Parliament. And we got loads of publicity off the back of it, not just the newspapers, but there was also a BBC film crew following us because they were filming a BBC Panorama documentary and they wanted to include what we were doing in that. And some of you would have seen that Panorama documentary. So that's what we did. It was a successful event. And I think what Hubert's touched on is actually a really important point. It may well be necessary, folks, to go and do something like this for the purpose of winning the court of public opinion, getting some media coverage, and frankly, winning the moral argument so that hopefully the legal argument can follow. There's a page on this website somewhere which is like the media gallery. There's lots of photos about things that were photos of the day of the event. I'd certainly be up for doing something like this if the APPG, because obviously it's the APPG that's actually organising all this effort. If the APPG thought it was a good thing to do, we could certainly look to see if some TTF volunteers were happy to do it. I've mentioned Bully Banks and Andy Candy a couple of times. Andy, if you feel up for it, please do share your reflections on what Bully Banks was all about in the old days before the APPG was up and running. It'd be interesting to some folks who may not know much about Bully Banks. If you're not in the, if you don't fancy doing it, Andy, just leave your camera off. The camera's on. Thank you very much, sir. Andy Candy, please take a moment to introduce yourself. For those of you that don't know Andy, Andy is an amazing campaigner, very, very supportive of the cause, an intelligent, articulate, very popular member of the TTF. And I'm saying all this because I mean it. And Andy's been absolutely battling under all kinds of stresses and strains and pressures, particularly recently. And I just want to salute the work that you do, Andy, not just for yourself, but also for trying to drag this financial services sector into a morally righteous place. Mr. Candy, tell us about Bully Banks. Thank you.
That's very kind of you, Andy. I appreciate all those words, and I'd reflect them back at yourself and the guys that you work with at TTF. I mean, it's outstanding stuff that you're giving a voice to all of this in a forum in which it can be brought into the sunlight. It's long overdue and long needed across a variety of different issues. I mean, to be honest with you, Bully Banks is so long ago now, it's just, it seems a distant, hazy memory, quite frankly. But a whole host of people got together and formed enough connections with MPs who were probably at that point more willing to engage with their constituents and were horrified at what had been done to them, and clubbed together to bring, banks and regulators to account for what they'd done. Notwithstanding the fact that we were still being subjected throughout the review to a massive fraud of the hidden credit, margin credit fraud. Which goes to the heart of this across all the issues. So, and sort of touching on Gertch's and comments made by others in relation to those contracts that were signed when you were agreeing to redress, you can't be held to a contract that you've signed as a result of a fraud that's been perpetrated on you. So if you're signing that contract and people like the FCA and the banks have actively conspired to conceal that from you throughout the whole process, you're signing it on the basis of a lie. So, and this goes to the fact of the people that keep claiming that we're timed out from these actions. The Supreme Court, or I can't remember which one, made a comment not that long ago that fraud unravels all. And this is what we've been subjected to on a massive scale. So I'm sorry, but we're not timed out on this. And we're certainly not timed out when you look at what's happening with the LIBOR at the moment and the outstanding work that Andy Verity and others are doing to expose the absolutely abhorrent, soul-destroying criminality at the heart of that issue, where you've got the SFO, you've got the FCA, you've got the Bank of England, and you've got top people in government acting in entirely inappropriate and quite frankly inhumane manner against small businesses and the citizens of this country. It's disgusting. It's beyond abhorrent. Yeah, I'm lost for words as to how to describe it. So for the people that say, oh no, you're out of time, all that, sorry, but bollocks. It's absolute fucking bollocks. And I'm sick and tired of people apologizing and making excuses about it. I've had enough of it, quite frankly. They're sitting there constantly reducing your expectations of justice and integrity and straightforward business dealings. If any of us acted as business owners the way these banks and regulators and utter bastards act, we would be out of business in 30 seconds flat, because no one would deal with us and we'd be cast aside. You don't run a successful business in that way. You run a bank that way. You run the regulator that way, by being dishonest, disloyal and conniving, quite frankly. And I've had it up to here, as you can probably tell. You've got, effectively speaking, the Bank of England coming out and putting up £50 billion to potentially rescue pension funds who are pretty much sophisticated investors, in response to margin calls on pension funds that they were sold by the same banks and institutions and dealers and whatever else. The Bank of England's put up £50 billion to keep them out of the doo-doo. And yet small businesses, not only did they say, let's not worry about them, we'll exclude you from access to justice, we'll exclude you from this, we'll hide the fact of what we've done to you with margin credit and various other things behind your backs. We'll keep that all concealed from you, and then we'll just kick you off into the long grass of review scheme after review, after lessons learned, after this, that, and the other. And I've had enough. It's bullshit. It's absolute outright lying dishonesty. And you'll have to excuse my thing. You'll have to put in a beat meter on this video if you're going to publish it, because I've just had enough. You know, how can the Bank of England and Andrew Bailey sit there and stump up? And I know they didn't spend out £50 billion, blah, 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 whatever. But the intention was there to rescue and to ensure that the pension schemes of this country didn't absolutely slide into oblivion because of shyster activities that they'd been up to. Sorry, £50 billion. Where do they get that from? On liquidity issues on all these different markets and bonds and all this stuff. Yet the businesses they'd missold these products to that got hit with the same margin calls that they weren't aware of because they'd had that whole aspect of the product hidden from them, it doesn't get dealt with. They literally farm them off into the bank's slaughter units to get not only taken apart, but assets stripped, go after their families' assets, go after their houses. I mean, you know, they literally are pretty much putting the rope around the neck, flinging it over the tree and hanging them. I mean, that's what the regulators, this government and the government before it and the government before that have all engaged in actively conspiring to inflict on small business in this country, which are the lifeblood of this country, quite frankly. It's not the banks. They don't produce anything. They just steal off people, quite frankly. I think that's probably all I'm probably going to say for now before I really properly lose it. But I think ultimately I come down to the fact that how can the Bank of England put up £50 billion saving supposedly sophisticated investors who should have known what they're doing, despite the fact you've even got the top people in those organisations writing to the government going, why are we being made to take on interest rate hedging swaps on pension funds when we don't need them. It's a completely useless product for us. And yet for us, we get slaughtered. We get fed through the shredder.
Yeah. Land for slaughter.
I think I'll end it there.
Mr. Andy Candy, I for one want to salute what you just said, sir. I really, really do. I really, really do. Well said. And we're not going to take a blind one bleep out of that. It needs to be said. You've spoken straight from the heart and straight from the soul. Well done to you, sir, for doing so.
Thank you. Well, thank you, Andy, because I mean, again, you provide a forum where this can be done, and I think you do an absolutely astonishing, mercurial job of managing some people, which through the we've all been through some very tough fights across the board. Generally, most people are fighting for justice. There are a few finicky little shits that still hang around. I think we know what I'm talking about, but effectively, the majority of people are absolutely amazing and outstanding. And I'm proud to see quite a lot of them on this call here tonight, and others that aren't here tonight, and they know who they are, and people here know who they are. But what you've done here, Andy, with TTF is provide a forum where these issues can be brought into the light and sunlight can be put on them, and people can speak their truth, and they can speak to what they've been experienced and the evidence of that, and it will be given time and it will be given airtime. And that is a huge thing for most people, whereas other places seem to use those evidence and that information for their own personal gain. That doesn't happen here. It's given out, it's broadcast, and you try and manage that process, which you're a genius at doing. So I salute you and I thank you, because if it wasn't for you, I wouldn't be here saying this, and neither would a lot of other people. And most people wouldn't still be in this fight, because others that have supposedly been running that fight for us have done very little actually to do it. And I'll leave it there, I think. But thank you. And to Alex and to all the others there, to Chelsea, to Alexandra, to all the team. They're brilliant.
Andy, thank you. A few hours ago, I touched on this earlier. A few hours ago, I burst into tears talking to some folks about the sorts of things we're talking about tonight. I'm going to try and stop myself doing exactly the same thing right now. Thanks, Andy. Thank you so much. Mr. Paul Carlier, please don't hold back, sir. Mr. Candy has shown the way. Well, tell it as it is, Paul.
Well,
but as quickly as possible.
First of all, I just want to echo Andy's comments and the sentiments there. You know, for several years prior to literally stumbling across you in the Transparency Task Force, I think it was in 2017, I'd kind of availed myself of various organisations or bodies that purported to help and provide support and be professional and knowledgeable, only to find that it was one cuckoo in the nest after another. And I know that everybody here has probably experienced a similar or had a similar experience at some time. But you know, I can safely say you and the Transparency Task Force are an organisation that wants to get to the heart of it, wants to get to the bottom of it, and one of the things that you do, as Andy kind of alluded to it, that you pull everybody together. And one thing the banks have been successful with over the years is divide and conquer. You know, they create the stress, they create the financial despair, and then it creates difficulties for people who are already struggling financially, already struggling emotionally, and it creates divisions within those people that really are all on the same side. And the banks lap it up and love it up. They're aided and abetted by the regulators who, I mean, how many of you will have had, we don't get involved in individual cases, when they know full well that there's thousands of you. You know, I know for a fact, like, you know, Julia Davey and all these others have gone to the FCA. We don't get involved in individual cases, but then having read all the cases of others who have also gone to the FCA and been told the same thing. I mean, it's just divide, conquer, and frustrate. And I do think that TTF and you do give us that, give us the forum, but give us the integrity. You know, there's and bringing people together. There are sometimes emotions get the better of people, but that's managed, and we keep the focus, and the focus is on justice. And as Simon said, without TTF efforts in terms of fundraising, would the JR have gone ahead? And obviously what we saw the other week was groundbreaking, you know. And a friend of mine whose wife is a judge read the decision, and he said to me, he said, probably the decision, the judgment is damning, you know, in every respect. I mean, it literally slaughters the FCA, but it's the cost capping order that is sending a message. They don't do, and I think Simon alluded to it, that cost capping orders are quite extraordinary or exceptional, and there's a reason for that. But when a judge gives one, it's sending a clear message to the other side: you're screwed. This is, I'm so convinced in the power of this case that I don't see there's any risk in them losing. So, I think that's something to really, focus on. I don't want to say it's as good as one. There's a long way to go yet, but it's a massive step. But yeah, I just want to, and I do want to touch upon this hierarchy of oversight. You've got a situation, and I don't know if you were following the post office scandal, because for me that's the benchmark, right? This is the ultimate, and yet you look at that, and you look at, it's all out there now. Everyone knows the truth. How many involved in the post office have been brought in and questioned under caution? This is the biggest, acknowledged as the biggest scandal in UK judicial history. The evidence is all out there. The post office lied. The post office prosecuted multiple people when they knew there was, there were concerns, and then when they all the evidence was out there, they continued to prosecute people they knew to be innocent just to conceal the fact they'd prosecuted, that there was flaws with the previous prosecutions. It's astonishing, but it's all out there, and yet there's been no justice for anybody. And we're in a similar situation here where bit by bit all the evidence is out there, and let's not, the judicial review, I know Simon said, and quite rightly, we're not there yet, but you read that decision, it's as damning as it gets, and you can sense the annoyance in the judge. It's like, why the hell is this even being brought before me? The evidence is there, do the right thing. And all too often we're seeing history used to be a case of justice wasn't done because of a lack of evidence. These days justice isn't being done when there's an absolute plethora of it. And I don't want to sort of this whole hierarchy. I know Andy alluded to rigged and the whole LIBOR scandal, and there are very serious wheels in motion there, and on a number of fronts. But I mean, only today, I mean, Andy's been with me on a difficult journey that involves breaches of the Suicide Act, breaches of the Fraud Act, and it's the documents I got today. You cannot possibly begin to appreciate the level of corruption that this exposes between the FCA and Lloyd's and the Metropolitan Police. I mean, I've posted it on Twitter today. It's not necessarily specific to this, but I blew the whistle on this, the very stuff that you guys are victims of now. You were sold these products because it was a way of generating markups. It was all about profit. I spent 2 years blowing the whistle and raising concerns about this at Lloyd's, and concerns with the pricing policy, a pricing policy that said for sophisticated customers where we need to be competitive, no markups. However, for non-sophisticated customers who have no idea where the price is, fill your boots. And that's what they were doing. It's in the pricing policy. A pricing policy I presented to Swift via his support team, and then I was then triaged out of the Swift review. So Swift never got to see it, and there's a whole other story coming on that now, and I think Households has said that the judicial review doesn't just expose that one ruling of Swift, it opens up the door for every issue with the Swift review, and including stuff where the FCA sought to manipulate an engineer and cherry pick the team that they wanted to be Swift support team so as they can control the narrative, and it's all there. So yeah, I think everyone just try and keep the faith, I think. But on the subject of those settlement agreements, I had a meeting with a law firm last year who are now taking on my case against UBS regarding what they did to me in 2011, but also regarding the settlement agreement that they, let's just say, got me to sign in January 14, and they did so without revealing the true facts and things that they had at their disposal. And that had I known, I would never have signed that, and certainly not for what I got from it. So they're satisfied that constitutes concealment, that I was press ganged into signing a document without the full suite of information before me. And had I done so, I would never have signed it. So therefore, and that's only stuff we've got recently. So they're confident that basically nullifies that agreement, and essentially you come to a position where you bang, okay, open it up and renegotiate, and we do it again. So I don't know everybody's individual cases, and as Simon said, you'd have to look at them, but I don't see how, when you have been deprived of information that would enable you, look at the Consumer Lending Act, this is really important, that says that it's mis-selling if somebody is not given all of the information that would enable them to inform their decision, and that's wrong. And there's legal equivalents of that. So if you have been deprived of information that would enable you to make an informed decision and help you negotiate an appropriate settlement, it's not worth the paper it's written on. So, you know, I think everyone needs to start looking at that and looking at ways to begin presenting arguments to have them re-looked at and reopened. That's all from me.
Well, thank you very much indeed. Thank you. And thank you, Paul and Andy and everyone else for some very, very nice comments tonight. Thank you. Really appreciate it. Thank you very much. I'm going to share my screen to draw your attention to a couple of tweets from last year. I still think these are phenomenally important tweets. Okay. This is James Hurley. Many of you know James, a very, very well-respected journalist. This tweet that you can see, he says, what then FSA boss Martin Wheatley said in private about pressure from ministers to go easy on banks by watering down a small business compensation scheme, and what he told Parliament a month earlier. I'll put a link to that one in the chat. This is interesting. Important to note, FSA records suggest it felt it resisted this pressure. However, the fact is a test was introduced that saved banks billions and excluded 10,000 businesses. Independent QC, that's John Swift, now KC, independent KC John Swift says regulator failed in its duties here. And the one underneath it, I think this is one of the most powerful questions I've seen in any of this space. The question is, and why did FSA, FCA and Treasury all lie about this interference? The question isn't, did the FSA, FCA and Treasury all lie about this interference? The question is, and why did they? Why did they? They did. It's making a statement of fact. They did. They lied about the interference. They lied about their attempt to get the FCA to reduce the amount of compensation payable. Another one here. Swift concludes FSA managed to resist the Treasury pressure despite coming up with a change that satisfied what that pressure was aiming to achieve. So what we're being asked to believe, ladies and gentlemen, is that the Treasury and the banks applied pressure to the FCA. The FCA miraculously resisted all of that pressure, but they happened to do the very thing that the pressure was asking them to do, which was to reduce the amount of compensation payable by the banks. I'll put that link in the chat as well. These are really quite profound. These are really quite profound tweets, and it's just a reminder, really, about the battle that we've got on our hands. And frankly, going back to what I started saying at the beginning, to my mind, I'm happy to go on the record. This is being recorded and it's going to be seen by all kinds of people. My personal view, that in relation to this matter, at least, the Financial Conduct Authority, supposedly one of the world's best financial regulators, has behaved as if it were morally bankrupt. And I think they should be ashamed of themselves. Quite literally, they should be ashamed of themselves. There's a lot of media activity about the idea that morale within the FCA is really low. I wonder if it is, and if it is really low, I wonder if part of that is that good people working there don't feel enthusiastic about the decisions being made by the senior people at the FCA. We're going to be bringing things to a close quite shortly, folks. We're going to go to, I think, Paul, did you want to come in again, Paul?
Just
go for it.
On that subject about people at the FCA and good people, and the same actually goes for Lloyd's, because in the last 2 years, I've been getting some really important help from people at Lloyd's who are actually in a position where they can't come forward because they were too scared to come forward in the past, and having not come forward, then now if they come forward now, the FCA will go after them like a ton of bricks. So it basically handcuffs people, but people have been very helpful with me in my own case and pointing out, are you aware that Lloyd's did this to you, and helping me and showing me documentary evidence that they can't go to the regulator with, because they witnessed this stuff 3 years ago, were scared to speak up, and because they didn't speak up, if they do not speak up now, the FCA will come at them for not speaking up at the time. That's the way it works. But also, I've now got evidence just recently where to show that in between August and September 2015, in the run-up to my employment tribunal, there was a civil war going on within the FCA, where the whistleblower team was trying to make people in the FCA treat me fairly and properly, and FCA Group Counsel were coming at them and literally preventing them from telling me stuff that they should be telling me, and then telling them to lie to me. And there was pushback, and I've got the internal emails, and and thankfully one of the people in the whistleblower team, they were told in an email, you cannot tell. They actually said to GCD, are we allowed to tell Carlier that if the tribunal judge asks us for an opinion, that we would have no choice but to provide an opinion as to whether his disclosures were wrongdoing or not? GCD come back and say, no, under no circumstances are you to share that with him. It's an established FCA protocol for whistleblowers. And they were, the lawyers in the FCA, trying to prevent the FCA whistleblower team from telling me. At the meeting that I had with them, they were very cagey, the FCA whistleblower team. And then I said something, and then one of them said, oh, Paul, if you're asking us that, to confirm whether or not, if the judge asks us for the FCA to provide an opinion, would we have to, if that's what you're asking us, we have to tell you that, yes, we would. They literally, that's how they got round it. And then the FCA GCD, internal emails show they went absolutely mental at the FCA whistleblower team, accusing them of telling me and accusing them of helping me. And when all they were doing was trying to get, do the right thing. I was entitled to know this, and they were telling me not to. So there are good people within the FCA, and it's probably something to think about. How do we encourage more to come forward and speak up?
Yeah, thank you very much indeed. Thank you, Paul. On that particular point, folks, some of you may be aware that the TTF is the secretariat to an all-party parliamentary group, not the APPG on Fair Business Banking, a different one. And I'm going to share my screen because the page is going to take ages to open, but I'll do it anyway. The APPG has been doing a call for evidence about the Financial Conduct Authority, and on the APPG's website, there's a section where you can go to testimonies from people talking about the Financial Conduct Authority, and on the page that's eventually going to open up, there are written testimonies, and there are also video interviews, people sharing their thoughts. Paul's in there, there's loads in there. There's even, rest in peace, there's even Ian Davis in there as well. I'll put a link to this in the chat. But just be aware, within that group, there are even some current stroke former FCA employees speaking out about the FCA. And it's not complimentary. That's what I'll say. It's not complimentary. Paul's point about maybe there are some other good ones who'd be happy to speak out is a really valid one, and we should try and do that. I just want to check in with Jackie, whether Jackie would like to come in. Jackie, just wave a hand at me, sort of thumbs up or thumbs down, depending whether you do or don't want to come in. You'd be very welcome to, Jackie, if you'd like to share your thoughts. And please take a moment to introduce yourself, because not everybody here knows you. Thanks, Jackie.
Yeah, hi. Hi, thanks for that, Andy. Yes, so I work. Sorry, just my screen's going mad there. Yeah, sorry. I work for the Secretariat for the APPG on Fair Business Banking, and so my main function there is research, really. My background is that I was also actually a victim of IRHP mis-selling myself, so I have got some personal experience, and I was involved in Billy Banks as well way back in the day. So I just wanted to say how pleased we were about the judgment from Mr. Justice Fordham. He was impressive, very impressive. he was obviously got he got the detail of the case very, very well, and he gave the KC, the FCA's KC short shrift and his argument short shrift, even though, as Simon Bishop said there was no actual finding on the arguments. He probed them, and he basically made the KC squirm quite visibly. So we were really pleased about that, and I just wanted to reiterate that our team, our legal team, were also very impressive. They are, as Simon said, they are working at a maximum of 25% of their own costs, and so I think to bring this back to the judicial review, although I recognise everybody here has got their own very heartfelt and valid problems that they're trying to resolve. I think the point about this meeting today is about this the judicial review, and I think two things really the APPG wants to focus on now is obviously fundraising, but also if people can come forward, if anybody is in that group of sophisticated who was excluded from the IRHP review scheme, if anyone who hasn't already had contact with us, or even anyone who has had contact with us, can come forward and talk to us or talk to the lawyers and provide some more background on their particular case, because that could well be quite useful, because the judge was quite curious. He did ask on more than one occasion, who are these businesses? I want to have a flavour of what they're like. And I think it would be very good to have a few case studies in our back pocket to be able to come forward with in the future hearing. So that's all I really wanted to say.
Jackie, thank you so much for sharing that. I can see Hubert's put his hand up. We'll come to Hubert in a minute. What you just said is actually really important, Jackie. I'm very, very glad you said it. Could you do me a massive favour, Jackie? Could you email me a few sentences explaining what you just said? Because the notes to this event are going to be circulated tomorrow. We can put those sentences in the notes being circulated tomorrow. We can also put it in the Transparency Times. And what the notes are going to basically say, what I'm asking you to write for me so I get it right, is please contact the APPG if you're somebody that was impacted by the exclusion that the JR is, or the judicial review is all about. So they can be like a case study or an example of the sort of people impacted. I got that right, Jackie, have I?
Yeah, that's right. I mean, obviously we're hoping that this will lead to a wider examination of other people who are impacted by the scheme, who felt that they didn't get a fair amount of redress or a fair hearing in that scheme. But at the moment, we have to focus on that particular group of people, which is the excluded people who were excluded on the grounds of sophistication, in inverted commas.
Yeah, thank you. If you specify that nice and clearly, make it kind of idiot-proof, because it's going to be me dealing with this. Spell it out what you want and why you want it. I'll make sure that we raise awareness of that. Thank you, Jackie.
Thank you so much. Thanks, Andy. That's great.
Thank you. Hubert's itching to come in, so we'll go to Hubert, then we'll go to Stephen Barker, and then we'll start bringing our conversation today to a close. Hubert, you're on mute, Hubert. You were off mute before, and you put yourself on mute, so now take yourself off mute. And I'll tell you what I want to do. After we've heard from Hubert, then Stephen Barker, I want to bring Joan Finch into this, because Joan did Joan, your eyes were brilliant. Joan did a brilliant bit of research about Justice Fordham a couple of days, I think it was, before the hearing. Just if you don't mind, Joan, just tell us a little bit about what you discovered when you researched Justice Fordham. I'm going to be in trouble. I can see it. I'm going to be in trouble. Hubert, over to you, sir. Then Stephen Barker, and that will give Joan at least 2 minutes to think about what she's going to say. Hubert, go for it. But take yourself off mute first, Hubert.
Okay, sorry about that, Andy. This is really one for Jackie. I was involved with the APPG way back long time ago. The last inquiry that the APPG had and putting forward to the committee the whole formation of the BBRS. And Heather Buchanan and Leslie Sheriff actually did a case study of my problem, and that was circulated to 650 MPs on the 3rd of December 19 to show just exactly what Danske Bank had done to me. So if you look back in your records, you'll find there is one there of a previous experience. I'm still fighting that case, Jackie.
So,
thank you.
So Hubert, just to clarify, were you excluded then on the grounds of sophistication?
I was damned on every front that you could think of. And indeed, there are some members on the panel in front of me that would be aware of what happened to me. It would take me too long, and I don't want to do that. But if you look at the case study that was done by Heather Buchanan and Leslie Sheriff, it gives you a very clear picture of what the bank did to me. But since then, I have uncovered a ton of evidence of misdeeds by the Danske Bank and what they did to me. And I now have some fairly able, capable bank directors who are now retired, thankfully. I've worked with for 30 years, and they're looking at the evidence that was put before the APPG and put before a tribunal, and they're saying this is a total nonsense. These people are crooks. They belong in jail. Now, I'm quite happy to say exactly the same thing. They belong in jail. It is not just an emotion of mine that I'm sounding off. This is years and piles of material that I have put together, and it started off with an article from the APPG, and that was back in Kevin Hollenrich's time, and my MP, Jim Shannon, spoke on my wife and my behalf in the House, and he was actually commented on by the Speaker about his uncommon language and his fierce condemnation of Danske Bank, and that is recorded in Hansard.
Hubert, I'm going to cut in there because I need to manage the time a little bit better than I have done. Okay, so we'll hold it there, Hubert. Hubert talk to Jackie, Jackie talk to Hubert, and have the rest of that conversation. Thank you very, very much. We're going to go to Stephen Barker, then to Joan Finch, and Joan will be pleased to know I found the email that she sent to me prior to the hearing, and I put the link to the SoundCloud bit. I put it in the chat, okay? So you won't need to speak for long when you're talking just a moment, okay? Thank you.
Okay.
Mr. Stephen Barker.
Yeah, just quickly, again, for Jackie Roberts, I would recommend you go to the TTF video evidence that was collected from a variety of people, 18 months ago now, Andy?
Yeah.
Okay. And this followed a questionnaire that had been compiled by the TTF. The TTF received those questionnaires, filled in, and then they invited people to do a video, and Andy acted as the questioner, and then the individual gave the answers. I've sent the link with regard to myself to quite a few people, and it's been well received in the sense that they thought it was pretty clear. And then, of course, they've looked at others on the TTF's website or that link. And similarly, because of the way Andy was orchestrating the process, if you like, it was very structured, and I think you might find that helpful. Now, we have learned a lot more since those were done, and I would readily admit that, but fundamentally, the issues remain the same. We are defined as retail clients by the banks. Supposedly, they should have done that before they did a trade, but nevertheless, they confirmed afterwards for many people that they were retail clients. And then we were deemed to be sophisticated retail clients. And the Treasury Select Committee in 2015 said there is no legal basis for doing that. The explanation given by the chairman of the FCA was that we just had to get a settlement, or we could have had another PPI on our hands, as if that was a bad thing. That those involved in PPI received large amounts of compensation. The thing is, you've got to join the dots in all this. You know, there isn't a single place you can go to for a straightforward answer that covers everything. But the TTF stuff, I think, is very good.
Thank you, Stephen. Thank you very much. Very kind of you to say so. Thank you. We're going to go to Joan Finch. Joan, just tell us a little bit about what you found out regarding Justice Fordham a few days before the hearing, because it was really, really, it raised our hopes when you found out what you found out. So just tell us a little bit about what you found out about the guy, if you don't mind. Thank you. Sorry.
Yeah, I think what I did actually, I was just sitting outside in the garden and I thought I'd just do a bit of research about this judge, and I found he's quite an amazing chap actually, and I think this country could do with a lot more people like him.
Yeah.
And I don't know how on earth the APPG versus the FCA case, I don't know how they managed to get him on it, because I would have thought they'd have had somebody quite different. The establishment, I would have thought, would have engineered it that it was somebody quite different to him. I just hope, and I don't know, I just hope he stays with the case. He's renowned for human rights, very much for human rights, and I haven't got my information in front of me at the moment, but I think maybe, Andy, that speech that I sent you, that video, I think it was maybe 2016, and he was outside the Ministry of Justice, and I've just got on my iPhone here. In an impassioned and angry speech, Michael Fordham asked if the government thought the justice system was an avocado, soft and easy to cut. On asking the demonstration what the building behind him was called, as the crowd cried out to the Ministry of Justice, he shouted through the megaphone over their voices, and I'll have to use the swear word here. The Ministry of Wankers, he said. And, you know, for a judge to go out there and do something like this, obviously this was a few years back. I'm not sure if he was a judge then or just a QC. But he does sound a really super guy who's very much thinking of the people and not the establishment.
Well said, Joan. Very, very well said, Joan. Thank you so much for sharing those thoughts. I've put a link to that speech in the chat so people can have a look later if they want to, Joan. And thank you for taking the time to do that research you did, because it raised our spirits and it raised our hopes. And well, I think we were all very, very impressed with it. Thanks, Joan.
Thank you, Andy.
You're most welcome. You're most welcome. We're going to go to Mike Lloyd now, and then we're going to start bringing our conversation today to a close. Mr. Mike Lloyd, what would you like to tell us?
Evening. I'm actually away at the moment, so I can't speak too long. I'm in a hotel bar. But for the last hour and 3/4, I can only say I concur with exactly what Stephen Barker has just said. My position is I would be delighted to provide information to the APPG. I am, like Stephen, classed as sophisticated, but I have documented evidence that has been signed by the bank in 2009 that says I'm a retail client and always will be. So more than happy to work with anybody, certainly more than happy to work with the APPG and provide all details as required.
Fantastic, 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 fantastic. Mr. Mike Lloyd, thank you very much. I really do wish I was in a hotel bar right now. I'd probably have myself a nice cold glass of Guinness. Thank you very much. We're going to bring it to a close, folks. I know he's not here, and I know he'll never know this, but I think when we close tonight and we applaud ourselves and our participation, we should also applaud Justice Fordham, because, well, he basically completely got it, and he made the right decision from our point of view anyway. So let's wrap it up there, folks. Let's give ourselves a clap to keep our spirits up, and let's say well done, Justice Fordham. He'll never know that we ever clapped for him. He'll never know this, but let's do it anyway. Thanks, folks. Have a lovely rest of your evening, and thanks again for those lovely comments that many of you have made tonight, both verbally and in the chat and everything else. Onwards and upwards, folks. Thank you. See you guys. Bye bye.
Thank you.